One of Mr. Beast's employees allegedly signed a non-disclosure agreement, and now he's creating videos exposing a lot of things that happened behind the scenes with the business. So the question is this employee in deep mess, or is it okay in the state of California? Hi, my name is Adam Juratovac, and I'm an employment lawyer right here in San Jose, California at Juratovac Law. And I advise people on non-disclosure agreements and also a lot of employment related issues every single day. That's what I do for work. So this is my one take. I have 9 minutes before my consultation at 1:30 p.m. and it is currently 1:21. So this is my take on what the legal rights that former employee may have in the state of California, and also what rights the business, Mr. Beast's business, may have in the state of California. Now, remember this. Although I'm a lawyer, I'm an employment lawyer in California, I am not your lawyer unless we have a separate contract. So none of this is legal advice. This is just legal education. Now check it out. Okay, so an employee signed a non-disclosure agreement with his employer saying that he would not talk about any of the confidential information or any of the actions that occurred in his place of work. Now, a lot of the times, those confidentiality agreements, those non-disclosure agreements, are required and mandatory in order to even come on to work with a company. And that's completely normal, especially in certain situations. I know here in the San Francisco Bay Area, there's a lot of tech companies and there's a lot of biotech companies with, a lot of resources and a lot of incentive to protect their work, to protect their confidential information. So you see it happen all the time. Sometimes people get provided a non-disclosure agreement within their employment agreement at the beginning. And also, there might be a severance agreement at the end, or there might be a quid pro quo saying, hey, if you sign this agreement, I will give you this amount of money at the end of the employment. Sometimes it's severance, sometimes it's separation pay, but either way, nothing is for free. So you're signing away some of your rights in exchange for some money. Now, the question is, what are you able to still talk about as an employee after you sign a non-disclosure agreement? Now, before we talk about that, because we all look at the language of the text in the contracts, and it's really, really scary, right? You're not able to defame, disparage, or slander the company or any of their board members, any of their executives, directors, employees, vendors, anyone they know under the sun, even if, or I don't even say even if, I'll say regardless of anything that happened. A lot of the times there's not exclusions or exemptions from that non-disparagement or defamation or confidentiality provision. But this is where things get tricky, because just in 2022, the National Labor Relations Board came out with an opinion letter that stated that they believe that blanket non-disclosure agreements, blanket confidentiality agreements, and blanket non-disparagement agreements are too overly broad, and if they're too overly broad, they will not be enforceable. Now, let me tell you what that means. Now, if let's go back to the first example that we had. By the way, it's 124. We go back to the first example where you are not able to slander, disparage, or defame any person the employer knows under the sun or anyone that they're connected to. Let's talk about defamation and slander. So first of all, defamation and slander have to do with falsehoods. So think about false facts that you are telling about another party, and that's completely incorrect, has no basis of any truth, and you're just there to really just trying to damage the reputation of the company. That is always illegal. Even if you don't sign a non-disclosure or a non-disparagement or non-defamation provision, you're still not able to defame and slander people, corporations, or businesses. Now, the really meaty part, the scary part here is the disparagement, because technically disparagement doesn't have to be a falsehood. Disparagement is any statement that would decrease the reputation of who you're talking about. So another way to talk about this in 2024 is a non-disparagement provision means you're not allowed to talk trash. You can't talk trash online, even if it's true. You can't talk trash on Glassdoor or amongst your peers, even if it's true. So that's what those blanket statements say. Now, what the National Labor Relations Board said with their opinion letter is those are far too broad, and we shouldn't be protecting a lot of activities that occur within your employment. So now, after that, the new NLRB opinion letter that came out, you're going to see a lot more confidentiality agreements and a lot more severance agreements and a lot more settlement agreements include language that you're not allowed to disparage, defame, or slander the company or anyone they know under the sun. And then there should be a second sentence added in there that says, nothing in this provisions restricts your right of speech under Title VII of the National Labor Relations Act. I'm pretty sure it's Title VII of the National Labor Relations Act, including your right to talk to fellow employees about unionizing, your right to talk to fellow employees about your workplace conditions, and your right to talk to fellow employees about management and getting treated better at work. So think about it this way. In your contract, it's saying all of these scary words that are talking about what you can't say and what you can't do and who you can't talk about. But the next sentence right underneath that line says, even though we said all this scary stuff, you're still able to talk about your workplace activities, unionizing in the workplace, or anything that could really help benefit your working conditions. That's something we want to protect. Now, that's federally, but we're in the state of California, and in the state of California, things are a little bit different. Now, before I start talking about this, it's 1:26. We got to scoot back to 2016 when the Me Too movement was going full charge. Now, after the Me Too movement, there was something called the Silence No More Act, meaning that sexual harassment and sexual assault and sex discrimination cases can no longer be subject to confidentiality agreements, even if you settle the case. Even if you settle the case and they say you can't talk about this with anyone, if you're one of those three things, if you're in that case for one of those three purposes, confidentiality provision would not apply to those actions. It does not apply to sex discrimination, it does not apply to sexual harassment, and it does not apply to sexual assault. Now, when we scoot forward a little bit with the California legislature, they realize that, other forms of discrimination are not okay as well, and we probably should not subject those to confidentiality provisions. So the state of California expanded that right to, you are now able to talk about any unlawful acts at work that you have reason to believe is unlawful. Now I'm going to say that again. In the state of California, we have a new law that says, regardless if you sign a non-disclosure agreement, you are always able to talk about things at work that you have reasonable belief to be unlawful. A reasonable belief. Now, think about it this way. You still sign a severance agreement. You still sign a separation agreement that says you're not able to slander, defame, or disparage the employer or anyone they know. But then there's this little carve out, and the thing about that California statute too is that statute also needs to be within your severance and settlement agreement. It needed to be that way. So if you have signed a settlement or severance agreement within the last 6 months, a year, you should double check to see if that language is there, because if it's not there, that employer is overreaching on their non-disclosure and defamation provisions that they're including in the agreements. But also, the lawyers that company has aren't updating their agreements to apply to today's current law. That's also another issue. That's a story for another day. Now, going back to the Mr. Beast fella, this guy was posting a lot of things online in his videos, and he was talking about what he believed to be unlawful, unfair, and kind of fraudulent things happening when the time he was working for Mr. Beast. Now, he was there for a month. It's 1:29, so I only got another minute to wrap this up. But he was only there for a month. But when I watched part of the video, I did see he was talking about things that he believed were unlawful. Now, one thing about the statute is it still hasn't been tested. It still hasn't been litigated. And one thing I tell all my clients is, if you want to sign this settlement agreement or severance agreement, I have to tell you the law. I have to tell you your rights that you have to follow under the provisions of this contract. But I also have to tell you the exceptions, which is you are always able to talk about unlawful acts that occurred at work that you have reason to believe, that you reasonably believe are unlawful. I also tell the clients, even though you're able to talk about some of this stuff that you have a reasonable belief of being unlawful, you do not want to be the poster child of what happens if a company wants to challenge a reasonable belief. What happens if a company, their reputation is damaged or tarnished so much where they do have to come after this individual for non-disparagement provision or a confidentiality provision or any type of non-disclosure? I don't want any of my clients to be in that position, so I always coach them up beforehand, even before we start negotiating any potential settlements, and let them know, hey, if your goal is to make a splash and if your goal is to communicate what happened to you to the world to make sure it doesn't happen again, do not sign this agreement. Let's litigate this case and go to trial. Let's win there. Because once you sign this agreement, it becomes very risky right now to think about the things you can talk about while at work, even if you have reason to believe they're unlawful, right? And the reason I say that is because there's not enough case law telling the lawyers where that line is. But one thing that could be very tough for an employee, especially if you're not working for a company where millions of people will be interested in the unlawful things that they did, like in this Mr. Beast former employee situation, it might not be worth it. And so you always have to weigh that out and evaluate those claims of whether you want to have your story told or whether you want to take a settlement, take a severance, and start building and moving on with your life. And that's something that clients need to evaluate at a very early point, because one thing that could be very detrimental for an employee is defending a lawsuit. Because the thing is, if one of these companies try to come after an employee, the company has lawyers, but that employee, that's not a type of case you find a lawyer to take on a contingency basis. That is a type of case where you have to pay a lawyer hourly to defend your case, and that could be very costly. So I just want to give everyone a little update about the California confidentiality laws along with this Mr. Beast former employee ordeal. And if here's a shameless plug, in the link in this bio, I have a defamation outline that I created a little while back that just kind of explains what defamation slander is, along with case law and what really the elements are and what it looks like. I'm going to be giving that away for free for the next probably 5 days. It's going to be in there. So if you're interested, check it out. It'll probably still be free when you check it out. If not, I like to price all my things, a reasonable rate. So this will probably be $20. And if you have any questions, here's a shameless plug. I'm not your lawyer right now, but feel free to give our office a call. And I guess this is now attorney advertising. So signing off. My name is Adam Juratovac. I'm a lawyer at Juratovac Law over here in San Jose, California. And it is now 1:33 and I'm 3 minutes over. Have a good day. Bye.